In recent years, it seems that a war against religious freedom is being waged here in the U.S. A case in point, the Little Sisters of the Poor's fight against the HHS contraceptive mandate will make its third appearance before the U.S. Supreme Court. Why is there such a concentrated effort to force an order of Catholic nuns to violate their deeply held beliefs? My next guest is very familiar with this case and many others. He's vice president and senior counsel at the Becket Fund and author of the book Free to Believe, The Battle Over Religious Liberty in America. Luke Goodrich joins us from Salt Lake City. Luke, let's start with this case. We discussed it a little bit earlier with Alex Azar, and I know you're very intimate with it. We talked about it last year. This case never seems to be settled. For the third time, the Little Sisters are again trying to argue away this HHS contraceptive mandate. Why is it back before the Supreme Court for a third time?
Well, I've been asking myself the same question. But for those who don't know, the Little Sisters are a group of Catholic nuns who have devoted their lives to caring for the elderly poor. They've been doing it for over 175 years in over 30 countries. And all this started back in 2011 when the Obama administration issued a regulation requiring many employers to use their health insurance plans to cover all forms of contraception, including kinds that could cause an abortion. And this regulation had huge loopholes for corporations like Exxon, Chevron, and Pepsi, but it didn't have a religious exemption for the Little Sisters of the Poor. So the Little Sisters faced a choice. They would either have to give up their religious beliefs about life beginning at conception, or they would have to pay multi-million-dollar fines to the IRS. So instead of that, they went to court, and we at Becket have been representing them for almost a decade now, and we're at the third time at the Supreme Court.
Now, as you mentioned, twice before the sisters have been, the court ruled in favor of them. And in 2018, the Trump Health and Human Services Department issued a new regulation protecting religious nonprofits. So how did the sisters find themselves now back before the high court? I mean, I get that a rule is not the law itself, but I thought in Obamacare, the HHS secretary had the jurisdiction and the freedom to define what the law requires in this area of the contraceptive mandate.
Especially after two different Supreme Court decisions telling the federal government, surely the most powerful government in the world can figure out a way to provide contraception without involving Catholic nuns. And so that's what the Trump administration did. They passed a new regulation saying religious groups like the Little Sisters of the Poor shouldn't be forced to provide contraception and abortion-causing drugs. But the problem is several blue states, the state of Pennsylvania, the state of California, then sued the Trump administration, sued the Little Sisters of the Poor, saying that the religious protection itself was unconstitutional. And remarkably, two different courts agreed with those states and said, hey, Trump administration, you cannot protect the Little Sisters of the Poor. So that's why we've appealed to the U.S. Supreme Court, and we're telling the Supreme Court, hey, third time's the charm. Now is the time to resolve this once and for all and let the Little Sisters get back to doing what they do best, caring for the elderly poor.
Mother Lorraine Mary McGuire of the Little Sisters had this to say about the state of their case. We're grateful the Supreme Court has decided to weigh in and hopeful that the justices will reinforce their previous decision and allow us to focus on our lifelong work of serving the elderly poor once and for all. Now, for those who haven't been to one of these homes that the sisters run, I've been to some of these homes. In New Orleans, here in D.C., it is extraordinary and beautiful work. But my question to you, Luke Goodrich, is a legal one. What is going to be your argument? Are you arguing the law as written that the HHS, the Health and Human Services Department, has the right to define what this contraceptive mandate means or doesn't mean? Is that the heart of your argument, or how are you going to argue it?
The heart of our argument is the Constitution and federal law that says religious people can't be forced to violate their religious beliefs unless the government has an exceedingly powerful and necessary reason for doing so. And here, it's simply plain as day that the most powerful government in the world doesn't have to use Catholic nuns to give out contraception. And the Little Sisters of the Poor should be free to carry out their work on behalf of the elderly poor without government interference.
Yeah, I mean, one would hope that this is the last visit to the Supreme Court for you and these nuns. I mean, is that what your hope is?
Absolutely. We're asking the Supreme Court once and for all make clear the government has to leave the Little Sisters alone.
Well, not only the Little Sisters, any religious nonprofit, or is it that broad?
You're exactly right. This case has huge implications beyond the Little Sisters, really for all religious nonprofits, not only with respect to the contraception mandate that's been kicking around for almost a decade now, but the states in these cases, Pennsylvania, California, they're arguing that all religious accommodations like this are somehow a threat to the Constitution, and so that would put at issue many religious exemptions across federal law.
Well, we'll be keeping our eyes on this case and how that final ruling, what that looks like. Just last week, President Trump updated the federal guidance on prayer in public schools. I want your reaction to this. According to that guidance, which is similar to the 2003 one published by the Bush administration, it reads, teachers and other public school officials acting in their official capacities may not lead their classes in prayer, devotional readings from the Bible, or other religious activities. But it goes on to say, students and teachers do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Luke, how important was this distinction in the new guidance?
This guidance is very important because there are a lot of misconceptions out there among local public schools where they think religion is somehow a threat, is somehow dangerous, and they need to stamp out religious expression within the public schools. So this guidance from the Trump administration is simply making clear to local school districts everywhere that there is room in the public schools for children to engage in voluntary prayer and religious exercises, and the government needs to not be afraid of that, but protect it and make sure students are able to practice their faith in school voluntarily.
Well, we saw this Christmas season a few school nativity plays and Christmas pageants where they had to pull out, any religious character or religious songs because, a local group was aggrieved and called attention to the school. Not the students, not their parents, but, outside groups were concerned about, the toxin of religion or religious belief around Christmas spreading to, through a school, a public school. The ACLU issued a statement saying the new guidance is nearly identical to the Bush-era guidance, at least regarding the prohibition against public school officials leading prayer and devotional activities, but they made no mention of the portion that protects students' constitutional freedom. Why that omission from the ACLU, do you think?
Yeah, I think these really get to the heart of what is the relationship between religion and government in this country. And the ACLU's vision, they want the government to be completely secular and even in some ways hostile toward religion. Now, and nobody's arguing that the government should force religion on school children or require school children to pray, but rather this guidance and what we're doing at Becket and what I've written in my book, Free to Believe, is that we want a government that recognizes religion as a natural part of human culture and as a welcome part of the public square and leaves religion free to flourish and leaves religious individuals free to practice their religion without government interference.
Luke, what about coaches or teachers unofficially leading prayers, not in their official capacity, but outside of their official capacity, after school or before school? Is that permitted, or might they get in hot water because the ACLU or somebody else might make the case, well, this is an instructor, this is a person in authority in the school who's using that authority outside those school hours to convert or in some way lead kids to proselytize them in some way?
Yeah, so teachers have religious freedom as well, even public school teachers. And the line that the courts have drawn, and I think it's a good one, is that teachers have freedom to pray on their own time, before and after school, even during school when they're not in a position of authority over children. What teachers are not allowed to do is to use their authority within the public school system to exert or pressure on children to pray. And that's a good line because we all have different religious beliefs, and we don't want government officials, be they office holders or teachers, dictating how people should practice their religious faith.
Yeah, the religious belief of a community, though, should not be disrupted by bureaucrats in Washington either, which, it's taken what should have been the protection of that religious expression and perverted it in some way into the silencing of religious expression. There's another important case in front of the Supreme Court, Luke, coming up this week that could have a huge impact on government funding for religious schools. It's called Espinosa versus the Montana Department of Revenue, and it involves the state of Montana's Supreme Court decision to invalidate a scholarship program because it might be used by students at religious schools. Tell us about this case, how important is it, and what the fallout could be.
Yeah, it's a hugely important case. And like you said, the state of Montana had a very simple scholarship program. Any taxpayer could donate up to $150 to private nonprofit scholarship organizations, and those organizations would help needy children attend private schools. Could be religious schools, could be non-religious schools. And that sort of a program is perfectly permissible under the federal Constitution, but Montana has a state constitutional provision called a Blaine Amendment. And that, relying on that Blaine Amendment, Montana struck down the entire scholarship program. And those Blaine Amendments, they have a terribly pernicious history. Back in the mid-1800s, when there was an influx of Catholic immigrants and Catholics started seeking funding for their own Catholic schools, many states adopted what are called Blaine Amendments, and they're designed specifically to cut off any sort of government aid, direct or indirect, to what they called sectarian schools, which was really code for Catholic. And now these old anti-Catholic state constitutional provisions are being invoked in modern day times to strike down scholarship programs that are really vital for needy children to attend the schools of their choice.
Right. No, well, we'll see what happens in the Supreme Court. How do you think this is going to end up, that case?
Well, the oral arguments just took place, and the court asked hard questions of both sides. It looked like it might be one of those closely divided cases. But at the end of the day, I think the court will recognize that these long-standing amendments are really rooted in anti-Catholic bigotry, and the government has no business cutting off programs like this just because they might benefit religious people.
Luke, before I let you go, the Becket Fund's involved in two very important cases that could really have a great impact on the right of Catholic and religious schools to choose leaders without government interference. Our Lady of Guadalupe and St. James Catholic schools, both in Southern California. Give us a sense of the background of these cases and what's at stake.
Yeah, so there's a famous Supreme Court decision from 2012 called Hosanna-Tabor versus EEOC. And there, the Supreme Court recognized unanimously that religious organizations need to be able to choose their leaders and their teachers without government interference. And now in these two cases, Our Lady of Guadalupe and St. James School, we at Becket represent two Catholic schools in California, and they let go of a couple grade school teachers because of poor performance. And these teachers have now sued the school trying to get their job back. But a core part of their job as grade school teachers in a Catholic school is teaching religion classes, teaching the catechism to Catholic students and leading students in prayer and preparing them for the sacraments. And the question in this case now is, can the government, through the court system, force the Catholic Church to keep teachers that they've dismissed for religious and for performance reasons. And if the court has that power, that means really the Catholic Church doesn't have authority to choose who is going to teach the faith to the next generation. So it's a case with huge implications, not only for the Catholic Church, but for religious organizations across the country.
We'll keep our eye on those cases and all the ones we've discussed. Luke Goodrich, thank you for being here. Luke's new book, Free to Believe, The Battle Over Religious Liberty in America, is available at bookstores everywhere and online. And of course, you can visit the Becket Fund at becketlaw.org.